Hi everyone. First of all, I wish everyone a good and healthy day. As you all know, the COVID-19 pandemic affects continues to affect our lives in every sense. So, in this session, in this part of the program, we are going to talk about the pandemic's effect on the Hungarian criminal justice system. In this context, I would like to introduce you András Lichtenstein for his speech titled Effects of the COVID-19 Pandemic on the Hungarian Criminal Justice System from a Human Rights Perspective. Okay, Mr. Lichtenstein, it's yours.
Thank you very much for the kind introduction. It's great to see you after 2018 in Szeged. And I'd also like to thank Professor Szözőer for the organization and for his team for the organization of this program. And I'm very grateful for having the opportunity to be here. Let me start my screen first to begin my presentation. Okay, do you see it? Yeah, I think my screen is being shared. So my topic is the effects of COVID-19 pandemic on the Hungarian criminal justice system from a human rights perspective, in line with the whole topic of this program. I'd like to start by addressing the criminal justice system as a whole, because I'm sure we all know that without the other. So I will start by the constitutional foundations. I will start my presentation with the constitutional foundations, international human rights and constitutional law perspective. Then I will be moving on to some COVID-related issues in Hungarian substantive criminal law, and then my favorite topic and also my research area is criminal procedure, and I will close by some COVID-related issues regarding prison and penal execution law. First of all, I'd like to address the forms of extraordinary legal order in Hungary, and I think this is especially important because when we are talking about constitutional law related issues during COVID pandemic, the term commonly used is the state of emergency. This is the common term in legal terminology, in legal English terminology. However, in Hungarian constitutional law, a very harsh distinction is being made between a state of emergency and a state of danger. And actually, what has been declared during and because of the COVID pandemic wasn't a state of emergency in Hungary, but a state of danger. And here you can see how extremely specified the specific forms of extraordinary legal order in Hungary are. And on the right side of the slide, you can see the state of danger, which can be declared by the government in case of a natural or industrial disaster endangering lives and property. Natural and industrial disaster may sound a bit abstract, but if you look at the prerequisites of the other extraordinary legal order forms, none of them would apply better to the current situation than a natural disaster. So a human pandemic is seen as a natural disaster in Hungary. This state of danger can be ordered by the government, and the supreme authority, the authority having the highest power, is also the government. This means that during a state of danger, the government has the power to issue decrees, also has the power to suspend the application of certain laws, certain acts of parliament, and also have the power to derogate from the provisions of laws and take other extraordinary legal measures. This can affect human rights as well. However, the original temporal scope of this state of danger is limited to 15 days unless the parliament enables and authorizes the government to exercise this power for longer. So if there is an authorization enabling by the parliament, this period of time, 15 days, can be extended. And I would like to show you the legislation timeline because this extension actually happened. So on the 11th of March 2020, the Hungarian government has used its constitutionally provided power enacted in the fundamental law of Hungary and declared a state of danger. This state of danger originally started as a constitutionally bound 15 days period. However, Parliament, with an act of Parliament, gave enabling and authorization for the government to extend the state of danger and to extend the temporal scope of other measures as well. This decision is what was being criticized on an international level regarding Hungary because there were some voices, critical voices, fearing that this indefinite period may affect the legal order and the rule of law negatively. However, as the pandemic situation was deemed to better and the threats were deemed to lessen, the Parliament and government both decided to cease the state of danger on the 18th of June 2020. However, declared a so-called epidemic preparedness and some measures are still ongoing, but not by a government decree, instead of by an act of Parliament, so as a standard legislation procedure. So I already mentioned that in a state of danger, so this in this period from the 11th of March to the 18th of June, government could issue decrees restricting and even suspending some human rights. And this happened, and we will see in the next slide what human rights have been affected by decrees, suspended and restricted by decrees. However, it is very, very important to stress out and to note that some fundamental human rights are still unviolable even in the state of danger, so they cannot be violated and breached no matter what. These are the following, as you can see on the slide: the right to human dignity, the right to life, the right not to be subjected to medical or scientific experiments, and the prohibition of eugenics and human cloning. You can see some of the fundamental human rights I put in bold, such as the prohibition of inhuman punishment, presumption of innocence, the right to defense in criminal procedure, the prohibition of ex post facto and retroactive criminal law application and legislation, and the procedural nabis in them. I wanted to collect these on this slide and put it in bold to show you how more than half of these unviolable human rights are directly criminal law related. So basically this means that even in the hardest times, criminal law principles cannot and should not be breached and should not be touched. This also implicates and implies the importance of criminal law restrictions, because obviously we all know that criminal law and criminal procedure is one of the harshest harshest measures of state against its citizens. And even when there is a pandemic, even in the state of danger, these criminal law related human rights shall be respected and should not be breached. So if not these, then what human rights have been affected by restrictive measures in Hungary? I think these are most of these are pretty common all over Europe. Basically, the rules of quarantine obviously affect human rights set out in the European Convention on Human Rights, such as the right to liberty, the right to freedom of assembly, and the right to freedom of movement. Next, I must tell you that in Hungary, there was no complete lockdown ordered. There were the so-called curfew restrictions, which basically meant that there were restrictions of leaving one's house, but these were somewhat flexible in a way that people still could go to work if they had to. They could go do their shopping, they could go out to do sports, and even in the decree, it was listed that people are allowed to go to the barber, go to the hairdresser, and the beautician. So it was quite flexible. It was not a complete lockdown, unlike in some other countries in Europe. Educational restrictions were among the first ones to introduce the basically universities were shut down and an extraordinary holiday was ordered right at the beginning of March, this affecting the right to education. I will talk about in detail about the restrictions on access to justice, because an extraordinary court recess all over the country was ordered, meaning that the right to a fair trial has been affected. Obviously, there were restrictions on freedom of assembly and association, even on elections. However, there were no planned elections in Hungary. So this in practicality had no significant effect. What very interesting is, and what I'd like to talk about in detail, is the restrictions by the means of criminal law on personal freedom and liberty, and restrictions on the freedom of expression by the means of criminal law. I originally did not plan to talk about these two latter topics in detail. However, after having heard the first lecture by Professor Rick Lawson, he mentioned this new Hungarian criminal law legislation, and I thought that it might be useful to you if I addressed this in detail. I also like to stress out that although you all can see how many international human rights set out in the Human Rights Convention have been affected by Hungarian government measures, there has been no official communication to the Council of Europe from Hungary regarding Article 15 of the Convention. So Hungary did not communicate about the derogation in time of emergency, in time of danger to the European, regarding the European Convention of Human Rights. This means that Hungary is still bound to it. This might be interesting because Romania had some similar situations, some similar measures, and Romania has filed an official communication and information to the Council of Europe about invoking Article 15 of the Convention and derogating some the application of some human rights during these times. And moving on to the substantive criminal law related issues, I'd like to tell you about this so-called scaremongering legislation. This is a criminal law definition in the special part of the Hungarian Code on criminal procedure. And before I show you the exact text of the disposition, I'd like to introduce this criminal offense a bit. So what shall be the legal interest, the protected legal interest of this scaremongering offense? It shall be the peace of public order, the preservation of the public feelings uninfluenced by fake or distorted news. But what's it all about? I'm quite sure that you might have heard the story of the shepherd or the story of the boy who cried wolf. If not, it's very simple. There is this boy who is looking after the sheep. He is a shepherd, and he's bored, and he to entertain himself, he scares the village people, telling them that there is a wolf coming to the sheep without a wolf being actually there. He does this one or two times, and the third time, when the wolf actually comes, no one believes him, and the wolf eats all the sheep. I just wanted to tell you this story because, in general, I feel like this public interest, this protected legal interest, is valid, and it is justified that there is such scaremongering offense in Hungarian criminal law. And I must also tell you that this existed in the late 19th century, late 18th century, so since 1879, we used to have this offense. I also tell you a story about a more recent case. This didn't come to the criminal courts eventually. However, the story was about a Hungarian bank, which was a significant bank at the time in 1997, and people began to spread rumors about this bank going to collapse and going bankrupt. And they were calling each other, and they were telling each other that you should take out all your money of this bank because it is going to be busted, and it is going to go bankrupt, and you will lose your money unless you take it out of the bank. And people began running to the bank, and they were queuing in front of the bank, and eventually this story, which began as a rumor and was partially unfounded, became a self-fulfilling prophecy, because if all the debtors take out their money from the market at the same time, there will be no money left in the bank, and at the end of the day, this bank collapsed. I must tell you that in this case, criminal procedures were initiated, charges were pressed against one individual by the Public Prosecution Service for scaremongering. However, for reasons undisclosed, the prosecution eventually has been terminated, so there was no adjudication. I also must tell you that the original protected legal interest concerns fake news or distorted news. This also means that no objective, valid, and truthful information shall be criminalized, even if it causes public disturbance. So this means if the boy cries wolf without a wolf actually being there, he shall be punished, he shall be criminalized. However, if there is really a wolf coming, then no punishment shall follow. And at least this is what we all were thinking until recently. However, government and parliament eventually, so legislation, changed the definition a little bit. And it says that anyone stating a false fact concerning a public danger at the scene of a public danger in front of a great public, or stating a true fact concerning a public danger distorted in a way to be suitable to cause disturbance or unrest in a large number of people at the scene of the public danger, commits a felony and shall be punished by up to 3 years. There is also a qualified, more serious case of this criminal offense in section 2. It's about anyone stating or spreading a false fact or a distorted true fact suitable to obstruct or to prevent the effectiveness of protection in front of a great public at the time of an extraordinary legal order, such as the state of danger, commits a felony and shall be punished by up to 5 years of imprisonment. And what's problematic about this this definition of this criminal offense? It's actually the criminalization of stating true facts. If you look at the texts, both section 1, both section 2, you will find that even stating a true fact relating a public danger can be criminalized if it is suitable or it is being distorted to be suitable to cause disturbance or unrest in a large number of people. And in many lectures, social media has been mentioned, and people's reactions relating COVID and government measures in social media posts. And I will show you a case study relating to this scaremongering criminal procedure. The story basically is that there was a 64-year-old man who posted a quite long post on his Facebook wall. It was poetically addressed to the Prime Minister of Hungary, and it included these sentences. The pandemic will reach its peak in Hungary on the 3rd of May, and the curfew restrictions or lockdown restrictions might be loosened as of 4th of May. So right the very next day of the peak. And he posed the question whether this will apply to everyone or only to the pensioners who are a burden to the budget. And I'm sure most of you are familiar with how some elderly people like to use social media as a form of expressing their political or other beliefs and opinions. And this post has been shared over 11 times, and there has been 90 comments quite quickly. What happened next was that police came knocking on the door of this man 6 o'clock in the morning the next day, and he was taken down to the police station and he was being interrogated on suspicion of scaremongering. So this was basically right after the new criminal offense came into effect. So at the very beginning. And investigation began. And I must tell you that in Hungary, most investigations are carried out by the police. So at the initial stage, police decide on the qualification of a crime. They decide on suspicion. However, after reasonable suspicion, the public prosecutor's office takes over the case. And what happened in this case was that the public prosecutor's office did not agree with the police on the initiation of a criminal procedure, and public prosecutor's office terminated the procedure. The reasoning was that public prosecutor's office thought that the act did not constitute a criminal offense because there was a lack of an element of a disposition of the criminal offense prerequisites, and further reasoning continued that in order to realize a scaremongering offense, the perpetrator shall state a fact or shall spread a false fact or a distorted true fact suitable to obstruct or to prevent the effectiveness of protection against the pandemic. The public prosecutor's office thought that the Facebook post in questions did not entail such statement or such spreading of facts, and therefore this post only qualified as an assumption. It was very hypothetical. It was basically a question, and as such, it was not suitable for the obstruction or for the prevention of the effectiveness of protection against the epidemic. So, and this was in May 2020. This was quite typical. So as of May, 80 similar procedures have been initiated. So this was not an individual separate case. There was many others, but as far as we know, in most cases, the public prosecutor always had this reasoning and terminated the procedure. And eventually, the police also altered their practice, and there are no longer criminal procedures initiated for such Facebook posts. So moving on to the further critiques and the reception of this modified scaremongering disposition. Academics critiqued that there is a lack of clarity in the disposition, and it is very difficult to interpret. Because, for example, what does a scene of public danger mean? Is it, for example, a hospital where there are a lot of COVID patients in the current situation, or is the internet also a scene of public danger? Because if we see the countries or the whole world or the whole Europe as the scene of public danger, then we must see the internet as the scene of public danger as well. They also expressed that the meaning, the interpretation of the effectiveness of protection is quite unclear and is not suitable for a criminal offense definition, because who knows what would happen without such statements or with such statements. We cannot foresee the exact effectiveness of protection measures in a suitable way for it to be used in criminal law. And this lack of clarity and these difficulties in interpretation might lead to arbitrary interpretation by some judges, and this could cause a threat to the consistency of adjudication, meaning that some judges say that the internet could not be a scene of public danger, and some say it could. So there are a lot of uncertainties. It also has been expressed, and also Professor Lawson addressed this issue, that this legislation might have a chilling effect, a so-called chilling effect on the freedom of speech and on the freedom of press. And I must tell you that the Council of Europe issued a level 1 red warning, red alert on Hungary, exactly because of this definition, because there has been fears that journalists could be prosecuted because of spreading such news, even if the news itself are true. I must also address how the Constitutional Court of Hungary reacted to the situation. There was a complaint filed to the Constitutional Court of Hungary addressing basically addressing these fears and regarding the lack of clarity and such issues relating to this new criminal offense. And formally, in a procedural way, the Constitutional Court has accepted the motion, as in they were discussing the matter, however, deemed the definition of this scaremongering offense constitutional. However, they set out a constitutional requirement and stated that only facts stated are punishable which were known to be false to the perpetrator at the time of the perpetration, or which were knowingly distorted by the perpetrator and were suitable for the obstruction or prevention of the protection during extraordinary legal order. So basically, the Constitutional Court of Hungary did not share the concerns raised by academics in the field of constitutional and criminal law. Moving on to the next topic, in substantive criminal law, just very briefly, I'd like to address another somewhat typical scenario. Regardless of our different legal systems, there are still some disobeying members in society in all countries. And in recent days, this case scenario has happened quite a few times all over the world, also in Hungary. The story was briefly that in the beginning of March 2020, people were queuing in front of the pharmacy, waiting to be let in and waiting to be serviced. And there were two individuals sitting on a nearby bench. And they were making fun of the people, keeping distance, and decided to go there, address them, and they were coughing on them, and they were shouting at them that they will crown their day. This being meant as a joke, because crown and corona are the same words in Hungarian language. So you might have read reports about such cases in the United States and under federal law. In some cases, for such conduct, for such acts, people were being charged with terrorism in the United States. Obviously, it's not very a standard practice in Europe. I would say that here in Europe, the most serious charges that could have been brought for such cases are attempted bodily harms. However, in this very case, in Hungary, a procedure was initiated, but it wasn't a criminal procedure. It was an administrative procedure for breach of peace, and these two individuals were given an administrative fine, so no criminal offense had been realized as per the decision of the authorities. And moving on to criminal procedure related aspects and criminal procedure related effects of COVID-19 in Hungary, I must tell you that as of 15th of March, an extraordinary court recess was declared by the government on the proposal of the president of the Curia, which is the High Court of Hungary, upon the proposal of the president of the National Judicial Council, and on the proposal of the prosecutor general. At the time of this being declared on the 15th of March, nobody knew how long this is going to take. Eventually, it ceased on the last day of March, and other measures were instituted. However, I want to address that in this triangle set out by the coronavirus, the human rights, and criminal procedure, the most pressing and most concerning issues and factors are time and presence, because obviously our life has slowed down. We were keeping social distance, and that has had a huge effect on courts as well. What measures have been introduced in Hungarian criminal procedure? So I have grouped these measures to time-related, presence-related, and other measures. First of all, it was preferred that all court procedures shall be postponed and adjourned if possible, and some of the statutory time limits have been increased, as you can see on the slide. Also, no complaints because of the protraction of the criminal procedure are being allowed. As for presence, the presence via means of telecommunication, via video calls are preferred. If not possible, then written statements are preferred over oral hearings, and it is also possible to exclude the public from the trial. Other measures, during the state of emergency, there were no in absentia procedures, meaning that if the defendant was at large or was in a foreign land that could not have been prosecuted, no private prosecution was allowed during the state of danger. A so-called file quarantine was introduced. That meant that any files, original copies, must have been taken to rest for 8 days without anybody touching them, to avoid physical contact with the papers themselves. And also parties were not allowed to take copies of the case files. So moving on, I would like to share with you my absolute favorite case of criminal procedure related human rights from Hungary, and this is the so-called Talabir case. As you can see on the slide, this is a quite difficult case from a procedural point of view, but this is why it's so beautiful. Long story short, in 2003, a criminal procedure was initiated against Mr. Talabir for vandalism. Charges were pressed against him. An indictment was filed, and in 2004, a first instance criminal court found Mr. Talabir, the defendant, guilty of vandalism. He didn't like his guilty verdict, and he and his defendant filed an appeal to the second instance appellate court, and in this appeal he sought acquittal. So he wanted his guilty verdict to be overturned. In 2005, the second instance Hungarian court informed the defendant that it will preside over the case behind closed doors, in chambers, in camera. So it will decide on the appeal, but the defendant and the defense counsel and the public prosecutor are not allowed to be there at this court session. The defendant and the defense counsel filed a motion against it and repeatedly asked the court to have a public hearing, because they wanted to be there, and they wanted to be able to express their grounds for appeal. However, this wasn't allowed by the second instance court, and in 2005, the second instance court found that the first instance judgment was correct and lawful, and upheld his guilty verdict without the possibility of him being there. This judgment became final in 2005, so there was no more legal remedies in Hungarian criminal justice system according to Hungarian criminal law. Of course, the defendant didn't like this verdict and didn't like this situation, and filed a complaint to the European Court of Human Rights and complained about his rights to a fair trial, concretely and expressly Article 6.1, the right to a public hearing, and Article 6.3, to the right to be present in person at the court hearing being violated. And eventually, the European Court of Human Rights agreed with the complaint and held that the right to a public hearing and the right to presence at the court session are very, very important fundamental procedural human rights, which cannot be breached, which cannot be violated, even if it's in a second instance court, and held that there has been a violation of Article 6.1 C and Article 6.3 of the European Convention of Human Rights. What's interesting about this case is that under Hungarian criminal procedure law, if an international human rights organ, such as the European Court of Human Rights, declares a a human rights violation in criminal procedure, it can result in a review in the Hungarian national criminal procedure in the very case. And this is what happened in this case as well. Following the judgment of the European Court of Human Rights, the Prosecutor General filed a motion for review to the High Court to the Supreme Court of Hungary, to the Curia, and actually the Curia held in this review procedure that the second instance court violated some procedural rights of the defendant and therefore annulled this judgment and ordered for a new procedure. And in this case, I think it shows beautifully how if human rights are violated on the national level, even if the judgment is final, the case can go outside the national criminal justice system to the international human rights level, seeking remedy. And if the complaint is deemed well-founded and human rights violation is declared, then there is a functioning mechanism in the Hungarian criminal justice system to address this situation and for remedies. So why is it important for us during the times of coronavirus? It's because even when there is a breach of public hearing, and even if there is a breach of the right to be present in person in criminal trials, it can be remedied, both according to international human rights level and both as in Hungarian criminal procedure. Yes, and last, very briefly, I'd like to address some prison-related issues. On the positive side, you can see on the pictures that prison inmates are manufacturing face masks as a form of non-punitive prison labor in Hungary. You have to know about this, that in Hungarian prisons, as a rule of thumb, as a general rule, prisoners shall be working. It's not a punishment, it's rather an activity, and they shall be working. This is not an employment contract, this is a special legal relationship, and the prison decides on the type of work. And during this time, because there was a lack of face masks, there was a lack of face masks. It was decided that inmates will be asked to manufacture masks. On the negative side, there has been a visiting ban in prisons since March 2020. This is a very harsh measure because the current situation does not found this, does not require this. So other restrictions have been lifted, but not in prisons. And one other issue that inmates and prisoners are complaining about the lack of visitation and their only means of communication and keeping in touch with their relatives is over the phone or over Skype, which is, in the case of a phone, the use of telephone in Hungarian prisons is pretty expensive compared to civil phones. And on the Skype side, the families of most inmates that doesn't have the means and access to broadband internet, and they cannot use this Skype feature even if it would be free. So prison law is not my area of expertise at all, but I wanted to show you these positive and negative sides and effects of the COVID-19 situation in Hungary, also in the field of prisons. And this was my last slide before saying thank you to you. And thank you for your attention. And if you have any questions or comments, please feel free to ask.